Hi everyone, I welcome you back to my channel, Ego Mindset at the Bar. Today's topic of emphasis is the topic of domicile in family law 1. And we are going to break down this topic in such a way that every one of you is going to understand it clearly. Uh, we are going to define what a domicile is. We are going to give the importance of a domicile. We are going to give the types of domicile. And as a bonus, I will take you through the distinction between nationality and domicile, which many colleagues tend to confuse. Now, to define a domicile, as a layman, a domicile is a place where a person is resident and has an intention to reside in that place permanently. Even if that person goes elsewhere in another place, that person has an intention to come back. That is the best definition of domicile. If you go to the Black's Law Dictionary, 9th edition, at page 523, you will find the definitions are similar because it defines a domicile as a place at which a person has been physically present and regards that place as home and intends to go back even after some time. Now, I shall take you through an interesting case of Robina Elina Kayanja Chiyinji versus Dr. Agre Kiyinji. That is Uganda High Court Civil Appeal number 41 of 2004. And in that case, court defined domicile as a country in which a person is presumed to be permanently resident or a person is permanently home. You can also look at the case of Witcher versus Hume, where Lord Wensdale observed that a very good definition of domicile is the habitation in a place with an intention of remaining there forever, unless circumstances occur to alter that intention. Now we have defined the domicile. I hope every one of you knows that a domicile is a permanent place of a person which he calls a permanent home. And even if that person goes elsewhere, he intends to go back. Take an example like you left the domicile of your father and came to campus to study. Your hostel is not a domicile because you have an intention to go back to your home and reside there indefinitely. I'm going to give you the importance of domicile. And in the importance of domicile, we shall look at number one as domicile determines the validity of marriage. This one is simple. You cannot marry without a domicile. If you go to section 10, subsection 1A of the Marriage Act, it says that one of the couples must have resided in the place they intend the marriage to be carried out at least 15 days. And if you go to the case of Adinai versus Adinai, the House of Lords stated that domicile is the legal home of a person and it determines their status of marriage. Now, we shall look at other importance of domicile. Domicile facilitates adoption. You cannot adopt a child unless you have a domicile. It determines the mutual rights and obligations of parents to their children. It guides on property and inheritance. Domicile determines jurisdiction of courts in annulment and dissolution of marriage, divorce. Because a court will not have jurisdiction if, take an example, you are domiciled in England, the Uganda High Court cannot determine your case. It means you will go to England where you're domiciled. And now, let us go to the types of domicile. And in the types of domicile, we shall start with the dependent domicile. We shall look at the domicile of origin, that one by birth. We shall also look at the domicile of choice. And to start with the domicile of dependence or the dependence domicile, I urge you to go and look at the book of Principles of Conflict of Laws by Abla Mays at page 194. And for it determines a domicile of dependence as it determines it as a place acquired by minors, married women, and persons of impaired minds. Their domicile moves on with the domicile of the persons they are depending on. You can also go and look at Section 11, Subsection 1 of the Succession Act, Cap 268. It states that a person may, upon marriage, acquire a new domicile of their spouse. And if you go to the case of Joy Kigundu versus Arak Awol, case of 2001, what held that a wife, as long as she is not judicially separated or divorced, her domicile follows the domicile of her husband. We are looking at dependence. You see, a wife depends on the domicile of the man. Now, if you go to the case of Bell versus Kennedy, what stated that children have a domicile of dependence tied to the domiciles of their fathers, unless in illegitimacy, that domicile may follow the domicile of the mother. We have seen children depend on their parents' domicile. That is dependency domicile. We now go to Section 12 of the Succession Act, which states that a person cannot, during minority, acquire a new domicile. If you were a minor, you are under the age of 18, you cannot acquire a new domicile. If you go to the case of Winans versus Attorney General, the case of 1904, court affirmed that minors cannot indefinitely acquire domicile. They should follow the domicile of those persons who have their custody. Now, I shall take you through another type of domicile, and that is the domicile of origin. Here, we should be very keen. The domicile of origin is the domicile of birth. Here is another way of saying it. You can also call it as the natural domicile. And the authority for this, the locus classicus case of Adinai versus Adinai, which stated that domicile of origin is a domicile assigned at birth by law. I urge you to look at Section 10, Subsection 1 of the Succession Act, Cap 268. It states that domicile of a child follows the domicile of a parent of the child, from whom the child derives their domicile of origin. If you continue to look at Section 10 still, Subsection 2 of the Succession Act, it provides that where parents of a child have different domicile, the domicile of the child shall follow the domicile of the parent who has custody over the child. That will be their dependent domicile. Now, we shall go to Section 15. We shall go to Section 5. Section 5 of the Succession Act, which provides that domicile of origin shall prevail until a person acquires a new domicile. Take an example. You are still a student. Your domicile is that of your father. If you choose to acquire a new domicile of choice, is the only way you can leave the domicile of origin. And in Adinai versus Adinai, Lord Westbury stated that every person at birth receives the domicile of origin of their parents. We have seen domicile of origin is got from the domicile of your parents at birth. Now, we shall go to another type of domicile, and that is the domicile of choice. The domicile of choice is acquired by a person when they reach the age of majority. This is a great example. If you acquire the age of majority, you can choose to choose a domicile of choice and leave your domicile of origin, the domicile of your parents. But you should show these two broad principles. You should show that there was an intention to stay in the place you are choosing. You must also show an overt act that the place you are choosing, indeed you are going to stay in it. Quote me very well. For your domicile of choice to be valid, You should prove that you have an intention to stay in the place you are choosing forever, permanent. You should show an overt act too. Now, here I will give you an interesting case of Thornhill versus Thornhill. It is a case of 1965. And in this case, the issue was the petitioner had an intention to stay in Uganda. Like, the issue was whether the petitioner had acquired a domicile of choice in Uganda. Now, some of the facts were the petitioner had an intention to stay in Uganda, and he took reasonable steps to buy some shares in a tea company in which he was working. What held that? The petitioner had established the acquisition of a new domicile of choice in Uganda, and lack of Ugandan nationality didn't affect his intention to reside in Uganda indefinitely. Colleagues, in this case, the petitioner shown quote that he had the intention to stay in Uganda. He also showed the overt act when he bought shares in the company. Now we have seen the three types of domicile: the domicile of origin, choice, and dependence. Let me now take you through termination of domicile. Domicile can be terminated, of course, natural factors like death, uh, divorce and separation, and on that I urge you to look at section 11, subsection 2 of the Succession Act, cap 268, which provides that upon dissolution of marriage or judicial separation, a spouse may acquire another domicile. You get? Now, I promised a bonus to distinguish for you domicile and nationality. These two principles look to be same, but they are totally different. If you look at the basis of acquisition, we say the domicile is acquired by birth, it is acquired by dependence, and it is also acquired by choice. For nationality, it is acquired by birth, registration, and naturalization. If we look at their legal nature, domicile is a private law. It falls under private law. However, nationality falls under international law and political law. And if you go to their changeability, domicile is easy to change, while nationality is somehow hard to change. Now, colleagues, we have seen the concepts under domicile. We saw the domicile of dependence, and the bottom line there is that the minors, women, married women, and children depend on the person on whom they are living with for their domicile. We saw the domicile of origin or birth attained at birth. We saw the domicile of choice attained at the age of majority. And that's today's session. I urge you to subscribe to our channel, like our videos, comment where you feel like you're not contented. I urge you to also look at our next channel, Lagos, Agola Legis, a channel handled by a legal genius who shall take you through several aspects of law. Thank you very much.